do is to make sure on how we get the logistics of the call. Again, the chief's going to call me. I'll come right to this position. When I start announcing the case, if council can rise at that point, and then you will do your appearance at the podium at that time. So I'll call Bilbrey first. And when I'm done, Casper, you'll come to the mic and your name, the name of the party, and the
The Honorable Justice of the Supreme Court. Hear ye, hear ye, hear ye. The court from recess now sitting.
Thank you. Please be seated. Good morning to everyone. To those of you that are perhaps watching remotely, we apologize. We're behind schedule this morning. So you may have signed in and questioned where we were, but we were taking a later recess than expected. So thank you for your patience. We would notice perhaps that there is an empty chair this morning. Would let everyone know that Justice Wall is under the weather today. He fortunately is feeling good enough that he is listening on our YouTube channel along with others, and in fact has emailed at least one question to us this morning that he wanted to ask. So he will be participating in the decision-making of this case. It's just and is listening to your arguments. So with that, I would ask Mr. Doug Shima to please call the 10:30 docket. Really our 11 o'clock docket.
The first case on the 10:30 a.m. docket for Monday, December 12th, 2022 is appeal number 123637, State of Kansas versus Dustin William Eugene Bilbrey, Saline County. Briefs both sides.
May it please the court, Dustin Bilbrey appears through counsel, Casper Shire, Kansas Appellate Defender Office, present and ready for argument. And Your Honor, could I please reserve 3 minutes for rebuttal? Thank you, Your Honor.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers.
Second case is appeal number 121956, State of Kansas versus Brady Allen Newman-Caddell, Johnson County. Briefs both sides.
May it please the court, Corey Call, appellate defender representing Brady Newman-Caddell, present and ready for argument. Would request 3 minutes for rebuttal, please. Thank you.
Madam Chief Justice, and may it please the court, I'm Jacob Gonteski. I represent the plaintiff, the appellee in this case, the state of Kansas, also a cross appellant on the conditional cross petition for review, present and ready for argument.
Your Honor, that concludes our 10:30 a.m. docket for today.
I will now call 123637 Kansas, State of Kansas versus Bilbrey. As counselor moving forward and getting settled, I would like to say to all four counsel, express my appreciation for your cooperation and shuffling the docket. And for those that may be tuning in on and surprised that they're hearing these cases, we did have to make changes to the docket last week to accommodate an emergency situation for counsel that had been scheduled to argue today. And we just appreciate your willingness to work and accommodate your colleague in that way and working with the court. So thank you very much. And thank you also, Mr. Shima, for doing all the legwork to make that happen. So, Mr. Shire.
Again, Your Honor, I'm Casper Shire appearing for Dustin Bilbrey. Dustin Bilbrey made a pre-sentencing motion to withdraw his no contest pleas to aggravated robbery and several other felonies in this case. The district court denied that motion, and this appeal focuses on two of the claims that Dustin presented to the district court to show good cause to withdraw those pleas. First, Dustin was never shown the bulk of the video discovery in this case, and he was on record with the court at least twice saying that he was not comfortable either entering into a plea agreement or moving forward to trial without seeing that critical discovery, which included surveillance footage of the conduct underlying these alleged offenses. The only reason that Dustin's attorney ever gave for not showing him that discovery was that Dustin was in jail. Second, on the morning of Dustin's trial, minutes before it would have started, the state threatened to arrest and prosecute Dustin's brother for months-old drug charges if Dustin did not decide to enter into a plea agreement. The district court committed two errors, reversible errors, in denying Dustin's motion. First, it applied a standard higher than mere lackluster advocacy to find that Dustin was represented by competent counsel. And second, it made a critical factual mistake in finding that Dustin, and not the state, was the one that injected Dustin's brother's legal fate into the 11th hour plea negotiations.
On the video question, don't you have to show court applied the Strickland standard to the first Edgar factor in order?
We have to show that they applied the wrong legal standard.
Which is
Yes.
Strickland. I mean, it's got to be, there's no other legal standard. It's either the good cause factor that's in the statute or it's Strickland. There isn't any other standard, right?
There's no other articulated standard that I'm aware of. No, Your Honor.
There's none that you're arguing, I guess is what.
No.
But where do you see that the court applied Strickland? And the reason I ask that is because when you look at the transcript of the court's denial of the motion, it specifically cited to Woodring and that case does not use Strickland, and there's no reference to Strickland in the court's order. So how do you get us to the fact that the court applied Strickland when it didn't cite it, and the law that it did cite in denying the motion specifically does not deal with Strickland? In fact, it cites Aguilar, which says you don't apply Strickland.
I'll point you to three things, Your Honor. First, at the outset of the district court's ruling, it references ineffective assistance of counsel, not lackluster advocacy. And when we're talking about, and that's on page 4 of volume 21 of the record. And when we're talking about ineffective assistance of counsel, obviously we're talking about Strickland and not about the lackluster advocacy standard. Two, later on in the district court's ruling, when it is specifically addressing the claim that Dustin's attorney didn't make the effort to show him this video discovery, the district court says in part that it's denying this motion because it hasn't seen statute or case law requiring Dustin's attorney to do this. That's not the question. The question is not whether or not there is black letter law that says Dustin's attorney had to do this. And by framing the question that way, it certainly looks like they're applying something like the Strickland standard rather than the much more relaxed lackluster advocacy standard that we see in cases like Herring. And third, I would urge this court just to read the entire ruling in context, because by looking at the hearing, it's clear that the district court is not looking to see whether Dustin's attorney's representation left something to be desired, but rather whether it can point to something in the law that says, yes, because I've got this case or because I've got this statute, this is something that I can find is ineffective.
And when I read the entire ruling, I don't get that. I mean, I see a district court judge that listed maybe a dozen different aspects of how the defense counsel worked really hard to communicate with the client, to make sure that he knew what was in those videos, because the jail doesn't have the capacity to show the video to him. Overcoming that, I mean, the court mentioned that this is a defense counsel that filed a motion to suppress that was successful. All of that is the discussion you would have about a lackluster representation. And we all agree the court doesn't have to use the phrase lackluster, or else there, right?
I agree to that, Your Honor, but
Get on the rest of it, because like I say, I read the ruling. I don't see what you're arguing in that. Where am I wrong?
well, Your Honor, I think the problem is, one, at the outset, the district court cites the ineffective assistance of counsel standard without citing the lackluster advocacy standard, which puts this ruling on the wrong track to begin with. But second,
It uses the term ineffective assistance of counsel. It doesn't state the standard, because the standard would be Strickland.
the standard for ineffective assistance of counsel is Strickland, but Your Honor, I don't think that the court needs to use the word Strickland to show that they're using the Strickland standard. I think by saying ineffective assistance of counsel, by demanding that Dustin show statute or case law showing that he's entitled to relief, which is certainly not the lackluster advocacy standard, the court is holding Dustin to a higher standard than it should have. And second, Your Honor, the fact that the district court made thorough findings is one of the things that the Court of Appeals relied on in affirming the district court's ruling. Our position is, if the district court applies the wrong legal standard, it does not matter how thorough those factual findings are. Thorough factual findings cannot save a district court order that is based on the wrong legal standard. So while I don't necessarily disagree that the court made thorough factual findings, I don't think that's the issue. I think the issue is, did the court apply a standard higher than mere lackluster advocacy?
Why you want to go to the case law that the district court cited in its ruling, and that case law is specifically on the good cause factors, not an application of Strickland.
And in fact, the issue there is Aguilar, which is competent counsel, and that's how she ended it. That's how she ended it. She said, I find that counsel was competent.
And that the competent counsel thing goes all the way back to Edgar. So the problem with saying, hey, I find that counsel is competent is because that there are two very different standards for determining whether counsel is competent, depending on whether it's a pre-sentencing motion, lackluster advocacy, or a post-sentencing motion, where you have to show constitutional ineffectiveness. So simply saying that counsel was competent, well, that's skipping to the end. It doesn't show that the district court applied the right standard, lackluster advocacy.
Did she invoke the Constitution?
He, at the outset of the hearing, referenced the ineffective assistance of counsel standard, and then later on said she was looking for statute or case law saying that that counsel had an affirmative obligation to show Dustin this discovery. And I think that's enough to find that she applied a standard higher than mere lackluster advocacy, Your Honor. I'd like to talk also a little bit, with the time I've got left, about the error of fact that we're alleging in this case. The district court found that it was Dustin who injected his brother into this plea agreement on the morning that his trial was supposed to begin. And it's our position that there is no factual support for that finding in the record. In fact, to the contrary, the evidence all pointed to the state injecting Dustin's brother into plea agreement.
Why does it matter? Isn't this prosecutorial discretion?
No. It matters because there is a big factual difference. It matters because the question we're trying to answer here is coercion.
Right, but when you talk about coercion, what's the definition of coercion? Backs you in a corner where you have no choice.
Right, sure.
Why does he have no choice? I mean, his brother committed a crime. Then why not just let your brother get prosecuted? Why was he coerced into taking a plea agreement? He made a choice.
He made a choice, but he made that choice, and he testified that he made that choice because the state was threatening to prosecute him on charges that were months old and that it hadn't seen fit to pursue before the morning of this hearing.
Right, but he didn't say that his brother was innocent of the crime.
I don't have any idea how he would know whether he was or not.
Well, there's no evidence in the record that,
Can't you also look at it, though, as sweetening the pot? Well, if you accept this plea, I'll also not prosecute your brother.
But whether it's sweetening the pot or not, it's incredibly coercive, particularly when, you know, a moment ago, Your Honor, you asked why it matters that the state asked rather than Dustin asking. It matters because if Dustin is asking, he's not being coerced into making the choice to plead. If it's the state saying, okay, you don't want to take that plea, fine, we're going to go out and arrest your brother and charge him with this drug case that we've been sitting on for about 10 months.
but they've been sitting on it for 10 months. I mean, it's a real case. I mean, I don't see how it's coercion. The guy, Mr. Bilbrey, didn't have to take the plea. Why is it I don't see where it's coercion.
Well, Your Honor, with all due respect, the defendant never has to take a plea. They always have the option to take their case to trial. And I think part of where you're coming from is to say that coercion is inherent in the process. And I agree.
No, I'm not saying that. I'm not saying that at all. I'm saying that, you know, he has a choice whether to take it or not. I mean, this is his brother made the decision to do what he did. And, you know, he's trying to protect his brother. I get that, but that's his decision. You know, I don't see how it's coercive. Coercive is, you know, backing you into a corner where you have no choice. You know what's coercion? I'm going to kill you unless you take this deal. You know, I mean, that's coercion. You have no choice.
Well, I guess I disagree, Your Honor. I mean, even if the choice is that stark, you still have a choice, right? You always have a choice. You cannot.
Or if something's illegal, you know, for example, we're gonna, you know, if we're gonna set your brother up in a drug deal, even though he's innocent, and we're gonna send him into jail.
Yes, and I see I'm out of time, Your Honor, but if I could quickly respond. I think it makes a big difference, again, Your Honor, here that we're talking about a pre-sentencing motion rather than a post-sentencing motion. We're talking about different levels of coercion. Certainly, I agree that, you know, threatening to set a false charge on his brother would have been more coercive than threatening to charge him with a crime that, for all apparent purposes, had lapsed. That doesn't mean that threatening to charge him with a crime that was months old and that the state had taken no action on up to that point was not coercive. And especially when it needs to be judged under a more forgiving good cause standard and not the higher manifest injustice standard. That is an error of fact that makes a big difference in the way this case comes down, Your Honor.
Quick follow-up, counsel. I think I agree with the gist of what at least I took from what you were saying, which is the plea bargaining process does have some inherent coercion in it, no matter what.
Yes.
The question is it appropriate or inappropriate?
Yes, I agree, Your
So my
Honor.
question is, do you have any case law that says that bringing in potential crimes charged against a family member somehow makes this inappropriate coercion?
No, I don't have any case law for
Because-
that.
I'm sorry to interrupt. I don't think you would be here arguing that it's coercion if the crime that the prosecutor forbeared prosecution on was actually the defendant himself. So the only thing that seems to me to set this apart is that it's a family member.
I think one thing that sets it apart is that it's a family member, Your Honor. And the second thing is that, you know, the state, at some point, the state knew about this 10 months before trial, right? The state, at least in the form of, you know.
The state does this all the time in plea bargaining. I don't recall any argument made by a defendant that somehow receiving a benefit of not being prosecuted, even for an older crime, is somehow coercive or inappropriately coercive.
No, I don't think that's inappropriate.
Seems like it's the brother issue. Like, for
It
example,
is-
I can imagine a scenario where, let's say it was a defendant's child.
Sure.
And start that actually, to me, I mean, I'm just sort of entertaining the argument. Whether it's inappropriate or not, I'm not sure, but it does seem to be even heightened version of coercion if it's your child, let's say.
Well, I agree, Your Honor, and that I think
That prompted my
that
question.
pops into mind the analogy to, the classic case where the prosecutor is in charge of the sink docket and the criminal docket and says, look, you plead on this, or there are going to be sink proceedings.
That was just what prompted my question about any
Right.
case law. Like, for any cases that talk about
I don't remember the cases by name. I feel like those cases exist. And I think the analogy is certainly there, Your Honor.
Just a factual question. My understanding was that Mr. Bilbrey had talked to law enforcement officers during his interview about not getting his brother charged. And that Mr. Abbey then testified that all the discussions on the morning of the plea hearing really went back to that conversation having been initiated then. Does that change? The fact that it is Mr. Bilbrey that just brought, even if it was disconnected in time in a different conversation, he had early on let his views be known that that might be part of his thought process. Does that make a difference?
I don't think it does, Your Honor. It's still an error of fact. First of all, it's still an error of fact that Dustin is the one that brought this up on the day of trial. That's still an error of fact that makes a difference in this case. And second, as the court alluded to, the timeline matters here. The discussion that you're talking about with law enforcement took place in May of 2019. And law enforcement, as they should have, made the standard disclaimers. Look, we can't make promises. We can't make plea agreements. We can't, bind the prosecutor to do what you're asking us to do or to not do what you're asking us to do. And that was, Dustin gave a statement, and that was where things were left. Law enforcement, I think, agreed to put in a good word for his brother, I think is the way they phrased it. And then we have nothing. We have nothing regarding brother's case until January of 2020, when the state is reviewing the video of Dustin's conversation with law enforcement and finds out that this case is out there. Then about a week before trial, the prosecutor asks somebody in law enforcement to prepare a charging affidavit. And that's sitting out there and waiting for, it's sitting there, right, waiting for I'm not sure what on the morning of trial. And I think all of those facts make a big difference in this case.
What's the factual error that you mentioned twice now about whether the defendant requested that his brother not be charged in the meeting between Abby and Sheehan? And
Yes, and that's on volume 21, page 12 of the record.
and I've got that one. So that's not supported by competent evidence, that finding?
I don't believe it is, Your Honor.
I mean, what we would have to do is go back and look at the testimony of the three individuals, right?
Yes, Your Honor.
Okay, and have you done that in your brief to show us why that's wrong? I'm just having trouble tagging that as error. Because I have it in front of me and I just don't know what's wrong with it.
I don't know what to do beyond telling the court that I read the hearing. I did not see the evidence that Dustin asked for his brother not to be charged on the morning of trial. The evidence was that the prosecutor offered that he didn't remember having a statement about Dustin's brother with defense counsel until the morning of trial. And these cases have been, there's been radio silence on this case.
But that doesn't preclude Dustin bringing it up.
But there was no evidence that he did, Your Honor. There was no witness that testified Dustin was the one that brought this up.
But was there evidence that he didn't?
I
I mean, there were conversations that weren't on the record. So how can we be assured that it in fact was the state that first brought it up the morning of the trial?
Well, the prosecutor himself testified that he didn't remember having any, that he didn't have any of these conversations with defense counsel before the morning of trial.
That
Oh.
doesn't tell me, though, that the state started the conversation. It tells me they had a conversation.
Well, the factual finding that the state injected this into plea agreements, or excuse me, that Dustin injected this into plea agreements is not based on anything in the record. If anything, the evidence says the opposite. But there certainly is no evidence that Dustin is the one that brought this up. Dustin asked for this on the morning of trial. And that's the problem, Your Honor.
But would you, the way that I read the record, and please correct me if you think that this is an incorrect reading, but the morning of trial, that it seemed like the prosecutor was not interested in any plea agreement at this point. And the defendant, Mr. Bilbrey, told his lawyer he wanted less than 111 months, and his lawyer said he's not going below 111. And Mr. Bilbrey said, I want to hear that out of his mouth. And then the prosecutor said, I normally don't meet with the defendants, one-on-one, but he went ahead and did that in this case, and even though it was eating into when trial was going to start. So they did meet together. And then the prosecutor said, I'm not sure who raised what at what time, but it was the defendant that initiated this plea negotiation in the morning. Is that right? That disputed?
No, I don't think any of that is disputed.
Okay. I mean, no, it doesn't go to your point, which is who injected this, specific item into the record, which I don't think that there's any evidence at all on who brought up that specific subject, right?
That's right. And that's the big problem we have with this ruling, is that the court is saying it was Dustin that asked for this. And it wasn't. And that makes a big, there was no evidence to support that. And that makes a big difference in this case.
Is the court, the state appears by Assistant Solicitor General Natalie Chalmers. Or just really quickly before I move to my argument, there is what appears to be a factual error in the Court of Appeals' opinion on page 5. And it goes to pretty much what you were just saying, Justice Dandridge. It is not in dispute that the defendant himself is the one that initiated this conversation the morning of. But on page 5, it says, but Abby testified he initiated the plea negotiations. While that he is ambiguous in context, it reads like they think Abby investigated that, but there is no record support for that, and that would not be factually accurate if that is what they're trying to say. And record 2025 is my record citation for the fact that Abby did not testify. He testified that the defense attorney came to him and asked him to come talk to his client. As to the things I agree with the Court of Appeals on, that there was no good cause here, I guess I'll go in the order that Bilbrey did, which I think my biggest issue on the failure to view these videos, one, I agree with Justice Biles that nothing here shows that the district court used the wrong standard. The court cited the right case law, and no one even argued the lackluster standard. So I don't think district court should be faulted for not using that magical word. But also, we still don't know why these videos matter. And I'm hard pressed to say defense attorneys' conduct is lackluster or anything like that, when there's no evidence that these videos, if the defendant had in fact seen them, would have been the reason that he went to trial. He pled knowing that he hadn't seen those videos, and there has been absolutely no evidence as to why the ability to view these videos means he would not have accepted the substantial reduction in the potential penalty.
Doesn't a defendant have a right to review all the evidence that is contained in his counsel's file? I guess I don't understand what the problem is here in him viewing the videos. What's the problem? And I don't think it's anything outside of the realm of what should be expected of counsel to review with his client all the evidence, or particularly the evidence he wants to see.
Right. I don't know if it was a timing issue. The only testimony I have is defense counsel saying that the jail didn't have the equipment. I don't know why defense counsel can't bring in a laptop and show
Yeah,
videos.
that's, it's
Um,
kind of, I didn't understand what the problem was
I,
in disclosing to his client what he requested to view.
I know the defense counsel said I went, it was in the police reports. I told him what was in the videos. That's all I thought I had to do. That's the only thing. I know.
So just piggybacking on what Justice Rosen said, not, whether it's an error of law, the issue that was briefed before us and that is presented to us for decision is whether there was an error of law in the district court's decision, whether the standard was too high. But really, what I read the entire record, and when you look at that, he raised this twice before the district court and said, I don't want to plea until I see all the evidence that has been garnered against me. And when you think about, whether it's a dash cam or whether it was a camera that was showing him, I mean, why shouldn't he be shown that? Why couldn't his lawyer have brought in a computer and shown him in the prison? I just don't understand. There could be things, why isn't that almost even a constitutional right to be able to see that? Because in order to build a defense, that there are things on there that he could point out. Well, I know that guy, there's a witness right there. That could be a witness for me. It is beyond me how that request was denied and brought, I just am perplexed. I do not get that.
And without knowing the jail's policy, I don't know, because to me, it does make sense that if a defendant constantly was asking to show videos, if you have time, you bring in a laptop and you show them the videos. I'm not going to argue otherwise.
Well, isn't it true that the jail may have a policy against laptops as potential weapons?
And
inside
yes,
of-
and that's what I don't
brings
know.
it in.
But isn't it also true that the judge could bring everyone over and they could use the court equipment to look at it in the courtroom? I mean,
And-
there's probably a solution, correct?
I have seen in other counties where if there's an issue like that, they make a conference room available, and it depends on police officers, deputies being available to be able to guard the defendant and resources and things like that. But yes, I've absolutely seen that happen. So I am not going to say that it is the best practice for defense counsel not to show defendant an evidence that the defendant wants, which is why I'm saying I think it fails the good cause standard because he hasn't explained why seeing these videos would have caused him to change his mind. He didn't say, well, now having viewed these
How can he say
videos,
that if he hasn't seen the videos?
he could have seen the videos before the motion to withdraw the plea hearing,
How-
and then
He asked for it twice in front of the judge.
no, I mean, after the plea, he could have seen the videos and presented them as evidence, and now saying,
How?
having seen this,
When he was denied twice.
he had
before
new
the plea.
counsel at that point.
Do you think that there was so you're saying that counsel was incompetent and couldn't but new counsel could have had him view it, but old counsel couldn't? You're making the
I
case for the other
I
side.
didn't say that old counsel couldn't. I don't know. There was no reason given. He just said Ottawa County Jail didn't allow him to do the videos. I don't know what the policy is here. But am I potentially injecting a 1507 of the plea withdrawal counsel? Yes, I am, because it is his burden to prove good cause. And how can he meet that burden when we don't even know why these videos, let's say the videos do exactly what the state says the videos do, which is prove the case beyond a reasonable doubt. So he wants to watch those videos, go to trial, get convicted, get an upward departure potentially.
Well, isn't it just as plausible that he was satisfied, that he understood what was in the videos, and that's why?
It is just as plausible as that, especially when the day he had his plea hearing, he said he was satisfied with counsel. He said he wasn't coerced, and now he's coming back and trying to change all of that in a motion to withdraw a plea. So I think the district court here made adequate findings. There's no legal error. And I also disagree on the other issue that there's a factual error. One, I don't know that the district court cared who initiated the conversation about if it was the defendant or the state that brought up the brother being charged. I didn't read that as a crucial finding by the district court, but I do think that if you read this record, there is nothing that refutes that. Substantial competent evidence. Abby said he didn't remember, but it was the defendant himself that brought it up in this motion to suppress hearing, or not motion to suppress hearing, in this interview. It said, I don't want my brother to be charged. I'll basically plea essentially if my brother isn't charged. So I do think there's substantial competent evidence that supports the district court's decision. And I don't think there was any abuse of discretion in this case, and the district court should be affirmed. And Justice Rosen, do you have a question? You look like
Yeah,
you might.
well,
Yeah.
and I don't know if you might be along the same line, because it gets to this coercion aspect. How far can the state go? Let's just take it out of, who initiated, who didn't. Can the state say to Mr. Bilbrey, if you don't take this plea, we're going to prosecute your brother. But if you don't, if you do take the plea, we're not. Is the fate of his brother a part of the consideration that can be given in taking a plea? And I'm just curious of what your position is on that. How far can the state go? And
I do think it depends. I mean, a lot of defendants have co-defendants, and those are regularly part of the plea bargaining process. I think the brother aspects makes it more interesting, and I would agree that bringing children in is even worse. But
even worse. So you categorize it as kind of it's close here. We could say it's even worse.
I just know that most parents would be, well, not all actually, but some parents would be more apt to protect their children than others. And that would be probably closer to the line of coercion. The brother, had the state brought it out of the blue with the brother never being mentioned, I think we would have a problem. But the fact here is that the defendant himself said, I will plea if my brother is not charged. I will take responsibility. That is what he said during this interview. That I think then kind of makes it something that the prosecutor can again mention and say, oh, you made that request. Well, we have no reason to honor it because you're not carrying through with your end of the deal.
I don't know if that's what you were getting.
Yeah, I mean, that's similar. I guess I will follow up with the hypothetical that was in my mind, which is, a hypothetical defendant has been arrested and charged with some serious crimes, and the prosecutor says, hey, we picked your kid up, your teenage son up for shoplifting 10 months ago. And, if you don't plea, we're going to charge him. That appropriate?
I feel like the lesser crime, the less coercive it is. I mean, shoplifting for a teenager is not the same as murder for a teenager. Like the more serious the crime on this scale of coercion, I think it's going to be a case-by-case coercion, and it's going to depend on the parent. It's going to depend on whether or not the parent then says, this is the reason I did that, or if that was just like, oh, cool, I was going to plea anyway. And that's just sweetens the pot, I think, as someone said today. So I do think it's going to be case by case. I'm not going to stand here and say there's a hard line, but I do think it is probably better practice for prosecutors not to drag family members into plea agreements without the defendant bringing it up.
What test would we use to determine where coercion crosses over from okay to not okay?
I don't, whatever the case law says is.
That's what I'm asking. What is the test?
I don't have a test or case directly on point, but I don't think coercion is not just, and it benefited me. I mean, it can't just be.
Right.
Because then plea bargaining can't happen
Right.
anymore.
I would,
So-
if all we mean by coercion is that the defendant accepts a plea in lieu of something worse.
Right, then every single plea would be coercive and it can't be that.
And
So
or we can just say that's an element of coercion that is part and parcel of the process. There's nothing inappropriate about it. But if we concede conceptually, at least, that there's some forms of coercion that are out of bounds, we've got to have some test, some standard against which to make those decisions.
I agree that a standard would be great. To me, it's as wishy-washy as the lackluster advocacy standard is, because I don't know the line on that. Strickland is much easier to apply for me than whatever lackluster advocacy may or may not be. So
Is your answer just that you don't
I don't
know of
know.
a standard?
I don't have a standard off the top of my head. If I could magically come up with one, I would love to do so, but I can't articulate the standard right now. Thank you for your time.
Mr. Shire, before you get started, I just have one question.
Please, Your
Um,
Honor.
You know, I pulled up that State v. Edgar, that this test came from, which, you know, the first one is competence. And this was a pre-sentence motion to withdraw that didn't discuss Strickland at all.
Okay.
I thought you were relying on that to say that it was a Strickland case, Edgar.
Well, look, I'm sure you're right about that.
Well,
I-
given the Edgar cases, you know, it might have been that there was also a post-sentence one also. I don't know.
If I'm understanding your question right, Your Honor, I think my answer is that the bottom line is a finding that counsel was competent is not the same as showing, well, then the district court applied the right standard to get there. Because whether or not it's pre-sentencing or post-sentencing, it's the difference between Strickland and lackluster advocacy. So just saying, well, we ended up by saying that by concluding that counsel was competent. Well, that doesn't show that the court used the right standard to get there. I think that's my argument there, Your Honor. And I had two other thoughts just briefly. First, this court fielded questions about prejudice. The prejudice in this case is that Dustin was forced to choose between going to trial and seeing these videos for the first time there, or accepting a lengthy prison sentence and never seeing the videos. That's not a choice that anybody should ever be forced to make in our system. Second, this court has been talking about degrees of coercion, and I think that's a very appropriate discussion to be having in cases like this. And, you know, my counsel was up here struggling to articulate exactly what that test should look like. And I would too, if I was put with the same question. It's going to be a fact-intensive inquiry. And
Do you have a proposal for us? Or do you find anything in case law?
I don't have any case law to point to, Your Honor, but because it's so fact-intensive, I'm not sure there's a better way to handle it than providing a non-exclusive list
It's just
of things that look like improper coercion.
you know it when you see it. It's the Justice Potter test.
Well, I don't know if it needs to be quite that wishy-washy, Your Honor, but, you know, we have the Edgar test already, right? What is good cause to withdraw a plea? Well, you look at these three factors, but if there are other things in there, you know, you can consider those as well. You consider the whole picture, but you have to pay attention to A, B, and C. So certainly, I think threats to family members could be part of a non-exclusive list that a court should be paying attention to when they're trying to make that determination, and should be. And that's particularly true when we're dealing with a pre-sentencing motion, good cause, rather than the higher manifest injustice standard. And I see that I'm out of time. Could I sum up briefly, Your Honor? The bottom line in this case is that Dustin did show good cause to withdraw his pleas. The district court committed legal and factual errors in concluding that he did not meet the good cause standard, and we are asking this court to reverse and to remand to reconsider that motion. We thank you for your time, Your Honors.
Thank you to counsel for your arguments in this matter. We will take this under advisement. We'll now call 121-956 State v. Newman-Caddell. Counsel settle in. I would note that Justice Standridge is recused from this case and will not be participating either in the arguments or in the decision.
May it please the court. Counsel, I'm Corey Call representing Brady Newman-Caddell. I'll request 3 minutes just because I have to do that when I stand up here.
Yes.
Thank you.
It's a good precaution.
Better ask twice than
Yes,
none.
so
Um,
never hesitate to ask.
The Brady pled guilty to aggravated kidnapping, 2 counts of rape, and 1 count of aggravated criminal sodomy. The district court granted the state's motion for durational departure, citing 2 factors. One, that it was a crime of extreme sexual violence and that Brady presented future dangerousness. The judge then sentenced him to 165. He was criminal history I. So he gave him a 165 on the kidnapping and doubled it to 330, 165 on the rape, doubled it to 330, and then ran them consecutive to 660 months. We challenged the both factors used. The first factor was that it was a crime of extreme sexual violence. And there are 2 parts to the being a crime of extreme sexual violence. The first, little I, and we're in, let's see, 2168 15 F little I. Let me select. And it, so little I describes which crimes sort of qualify here, and 2 little I describes the individual characteristics of the defendant. We're not dealing with 2 little I, but I think it's a little like the sentencing grid, where you have the crimes that were here and the individual aspects of the defendant. But we're talking about a crime of extreme sexual violence, and there are 5 crimes listed, or 5 categories listed here. The first of which we're talking about is a crime involving a non-consensual act of sexual intercourse or sodomy with any person. And the problem we have with this is the first crime that they departed on was aggravated kidnapping. And here they kidnapped the victim, and during the course of that kidnapping, they raped her and sodomized her. So factually have a non-consensual intercourse or sodomy. But according to the statute, kidnapping does not contain an element of non-consensual act of sexual intercourse or sodomy with a person. So the question is, are we looking at the statutory aggravated kidnapping? Did the legislature mean, when they said a crime involving a non-consensual act of sexual intercourse, did they mean the statutory crime, or did they want the court to look at the individual facts? And this court—
Doesn't the word involving suggest look at individual facts?
I don't think so. I don't know.
Well, when we're talking purely in the realm of law, we never use the word involving. We use words like elements, but not involving, right?
I don't know if that's always true. I'm trying to craft how they would write it. A crime with an element of
What about requiring?
I guess it still seems, and I suppose most of those could work. Those could work. I guess the initial question is whether it's plain and ambiguous, or whether it's plain and unambiguous, or whether it's ambiguous. And this court sent out an order asking for talk about Bruce v. Kelly, which, by the way, we're big fans of those orders over at the Appellate Defender Office. We like no one coming in. And so you look at the overlaying, the language overall. And I think part of that may be involving. I'm not sure. I'm having trouble thinking of either way of examples where we obviously use involving to mean the individual facts, or obviously the other way. And I'm having trouble thinking of that. One thing that the Court of Appeals said, and that the state argued, I think it's probably their best argument, is that if you look at the other categories here, the legislature named certain statutes. So they one of the categories is aggravated human trafficking as defined in 215426, or commercial sexual exploitation of a child as defined in 216422. And the state's argument, the Court of Appeals said, well, if the legislature had intended the statute rape, they would have said rape as defined in this statute, or sodomy as defined in this statute there. And that's a good argument. We've made that argument. That's a way you can look at statutes. I think it's more difficult in this case with the rape and the sodomy statute because it doesn't read very cleanly. And that may not always be a priority with the legislature, but if you look at the rape statute, you have 5 different categories, 4 of which deal with non-consent, but the middle one, C, is less than 14. So they would have to list out rape as defined in 2155 A1, 2155-01, 2. They would have to list those out. And sin with sodomy, it seems like they wanted to cut. You have the animals involved in the non-consensual sodomy statute, which you'd have to accept out. And so it seems like this just seems a cleaner way to make the same point. One other thing if we look then at the entire aggravated, the language that the court used in the entire aggravating circumstances list, it looks to me like the legislature used the term offense to mean the individual circumstances of the crime, and crime to mean the statutory crime. So you have in 2C, that's C2C, the offense was motivated entirely or in part, blah, 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 blah. The subsection D, the offense involved a fiduciary relationship. They didn't use the crime there. They used the term offense, which seemingly that would have a different meaning than crime. Additionally, if you look at 2B, it says the defendant's conduct during the commission of the current offense. Well, that seems to be pretty clear, doesn't it? That if we're talking about the conduct during the commission of the offense, and if you also look at subsection H, the crime involved 2 or more participants in the criminal conduct. So they're qualifying the crime by saying in the criminal conduct, which I don't think you need to do if the term crime means what happened in the criminal conduct. So I think if you look at those, if you're going to say that if you're looking to see, is this plain and unambiguous by looking at the other words used in the statute, then I think it shows that the crime is, as a crime involving non-consensual act, is talking about the statutory crime and not the individual facts. I want to point out that if it's not plain and unambiguous, and there seems to be a lot of disagreement here about this. So if it's not plain and unambiguous, then you move to statutory construction. And it seems to me that most of what the Court of Appeals did, and they said it was plain and ambiguous, and the statutory construction factors that this court would use to determine the intent are very similar to the facts that we use to determine if it's plain and unambiguous in this. I mean, there are lots of other ones, but I'm not sure they apply here. And so I think if this court finds that you can look at the other language in this subsection and are unable to determine the meaning and it's ambiguous, then I think it's difficult to say that the rules of statutory construction prove that the states that it means the individual that acts of the crime itself. Additionally, you have the rule of lenity, which is always important, but I think it's especially important in a statute like this, which is a notice statute. It's a statute designed to put the public on notice that if you commit these acts, then the state will punish you. And to the extent it's ambiguous, and that notice is ambiguous, I think it needs to be interpreted in favor of defendants most narrowly so that that notice that is given is very clear and people understand exactly what conduct is being prohibited. Moving on to the future dangerousness, the Court of Appeals didn't reach this argument because you only need one factor, which I'm not sure in all cases that should be I think sometimes you have a one factor that's overriding. Here, I think the future dangerousness is I think that's probably right. I didn't argue that anyway, but they didn't get to future dangerousness. But if this court finds that crime, look at the statutory, so that wasn't a valid factor, then we move to whether it was future dangerousness. And the argument here is that under Apprendi, after Apprendi, any element which increases the time person serves beyond that by a jury like this did, it's an element of the crime. This is essentially an aggravated kidnapping. It's an aggravated rape. That's what the upward departure means. So it's an element of the crime. So it has to be statutory because we need to put people on notice of these crimes. And here, this is the legislature states that this is a non-exhaustive list. I think that's the next thing. And so they say, well, yeah, this is a factor. And pre-Apprendi, this court has said future dangerousness, you can do that for an upward departure. But that was before it had to be an element of the crime. And now that doesn't work. The state cited cases, but I believe all of their cases are either pre-Apprendi or they involve dispositional departures, which aren't subject to Apprendi. And so there was a Court of Appeals case, State v. Snow, which said that this exact issue, I don't know if it was future dangerousness, but that statutory factors can be an element for a departure. And they relied in part on the federal death penalty statute, which says that you can use non-statutory factors to impose the federal death penalty. The important thing there is that under the federal scheme, you still need to have at least one statutory factor. You need to get in the door. And then once that has been, because there's two decisions, right? Does this person qualify for the death penalty? Or in our case, does this person qualify for an upward durational departure? And then the second question of, well, should they actually get the death penalty? Or in our case, how much time should we give that person? And so what we're dealing with here is the threshold question of is the district court authorized to go beyond the jury's verdict? And that has to be a statutory element. Even under federal law, that has to be a statutory element. Now, once that's met, then the judge can consider all kinds of things, right?
How do we get to Apprendi when your client waived the jury trial, knowing that there would be a departure factors being as part of the plea? I mean, didn't your defendant in essence waive an Apprendi type?
Well, I think the difference, I think, is if the judge, I think if the judge had made sort of the factual finding, I was challenging the factual findings necessary to satisfy the element. But that's different. I'm not doing that. This is whether or not there can be at all the idea of non-statutory factors. I don't think he waived that aspect of it.
Why couldn't there be non-statutory factors if a jury made the determination?
Because the public needs to be on notice as to what constitute the elements of a crime.
Like so it really goes back to the notice issue, not.
Yes, yeah, and again, there are two types of notice. There's I think there's the idea of once you're charged with the crime, the state has to give you adequate notice of what you're charged with so you can prepare your defense. We're not challenging that at all. There was certainly adequate notice of charging and all of that. What we're talking about is prior to the commission of the crime, the public has to have notice of what is being illegal, what the state will punish you for. That's the notice that we're trying. We would ask that this court find that neither departure factor was valid and remand for resentencing.
Madam Chief Justice, and may it please the court. I'm Jacob Gonteski. I represent the plaintiff, the appellee, the cross appellant, the state of Kansas. And by stipulating not only to his guilt, but to stipulating to the fact that his crimes were crimes of extreme sexual violence, that he was a predatory sex offender, and that he presented a risk of future danger to the public. Mr. Newman-Caddell waived every argument he has before you today. He waived them because both arguments rest upon, as you heard opposing counsel say this morning, they rest upon Apprendi, and Apprendi's foundation is about the right to have a jury determine the facts that will elevate your sentence. And this defendant not only waived his right to a jury to determine his guilt, and he not only stipulated factually that the aggravating circumstances were present, he stipulated further that they were substantial and compelling reasons to depart. And he even went a step further and he stipulated that they were not outweighed by any mitigating circumstances. He went as far as he could to tell the court, I'm stipulating, I'm agreeing to the state's case. I'm agreeing to my guilt. I'm agreeing to their departure. I'm agreeing it's substantial and compelling. And I'm agreeing it's not outweighed by any mitigating circumstances.
My understanding, at least in part, of defendant's argument is that he claims as a matter of law that ag kidnapping cannot be a crime of extreme sexual violence. Do you agree with that?
That is his argument, yes.
And wouldn't it follow from that that you can't stipulate to an error in law? So at least as far as that argument's concerned, maybe would you agree that we still have a live issue here?
I believe you do, to the extent that although there has been a threat of case law that you can plead guilty to something that's not a crime necessarily. His was, and my argument in response to opposing counsels is that his argument that it is not a crime of sexual violence is it contravenes the statute itself. When you look at how Mr. Newman-Caddell was actually charged, I'm not looking at the affidavit, not looking at the underlying facts, but how he was actually charged in this case, what made his aggravated kidnapping charge stand on the complaint is that he committed a kidnapping to hold such person to facilitate the commission of a crime, to wit, rape and or aggravated criminal sodomy. Both of those are crimes that involve non-consensual acts of sex. That's essentially an element of his kidnapping.
Well, if it was an element of his kidnapping, wouldn't the convictions be multiplicitous? And it can't be an element. Otherwise, it runs into the multiplicity rule.
If it can't be an element, then it wouldn't be subject to his Apprendi argument. And he's making an argument that it's an element because it elevates his sentence.
Well, maybe I'm the one confused, but as I understand the argument, it is, look, what this statute means, this extreme sexual violence statute, it means that you can find this factor if the crime includes as an element a non-consensual act of sexual intercourse. And you would agree that ag kidnapping does not necessarily have to include a non-consensual act of sexual intercourse.
I agree with that.
So the question is, does the statute, what is the plain meaning of the language, a crime involving? And that seems to me to be a question of law.
I agree.
And so I guess I would ask you to talk about that, because if that's all true, then what the defendant stipulated below really isn't relevant.
It's a question of law to the extent that when you're interpreting that statute, you're examining the crimes that Mr. Newman-Caddell committed.
Yeah, the fact.
The facts, exactly. His kidnapping, his aggravated kidnapping would not be a crime of extreme sexual violence if he did it to obtain a ransom, for instance. And the departure criteria wouldn't have been satisfied here.
But what's your best argument that the plain meaning of the words "a crime involving" tells us that we get to look at the facts?
Because that provision of the departure statute does not narrow itself to particular crimes by statute number, as do the factors below it. The legislature absolutely could have confined this to only certain crimes in the Kansas Code by listing them specifically. And I believe our theft statute does that when it elevates thefts to various levels, says if you've been convicted of theft under KSA and so on. And so under that statute, we can't use out-of-state theft convictions or municipal ones, for instance. Contra to that would be something like our DUI statute, which is a much broader umbrella and can capture out-of-state because it doesn't narrow the prior convictions just to 8-1567. Likewise, this statute does not narrow the crimes that involve non-consensual acts of sexual intercourse to just rape under KSA 5501 or aggravated criminal sodomy and so on. It does some of those specifically later within the very same statute.
So it's sort of an imperi materia argument combined with the broadness, I guess, of the word involving. Is that a fair summary of your?
It's a very fair summary. And that was my in attempting to divine between the lines of this court's order, which invited the parties to be ready to prepare to discuss the impari materia aspect of this, my vetting of this case was that this is the very statute that question was posed for. And when you look at it in total, it not only defines certain crimes as crimes of extreme sexual violence by statute number, but subsection A is a broader umbrella than that. That does invite a fact finder to examine the facts of their specific offense. And this, it cannot be disputed, was all four of the crimes were centered on acts of non-consensual sexual intercourse. These are heinous and atrocious facts that I won't go through with the time that I have remaining, but suffice it to say, no one can make with a straight face an argument that these crimes were not crimes of extreme sexual violence. To the extent that opposing counsel says, well, this would just invite a fact finder or a sentencer to depart on every rape. That's not true, because the crime of extreme sexual violence aggravating circumstance is not cabined to only that the crimes involve non-consensual sexual acts. The fact finder also has to find that they were committed by someone who is a sexual predator. And that is not every rapist in every case by law, does not, because a sexual predator, a predatory sex offender, has a very specific definition within the very same statute, which narrows the class to which this aggravating factor can be applied to. And it narrows it substantially. While it narrows it substantially, it still captured Mr. Newman-Caddell, even though he came back as a criminal history score of I. But by virtue of all of the sexual offenses he had committed prior to this one that had gone unconvicted and uncharged, he still rose to the level of being a predatory sex offender because of the acts he committed against others, including the stranger, home invasion, rape, and the victim in that case that testified in the sentencing in this case. So even if, though, that aggravating circumstance is not found to apply to the aggravated kidnapping, there's been no argument made by Mr. Newman-Caddell all along the way that that factor, that aggravating circumstance, did not apply to count 2, the rape. And so that factor can be applied to count 2 to the rape to double that sentence from 165 to 330. The other factor that was found that Mr. Newman-Caddell stipulated to is the future dangerousness factor. That one could be used to elevate count 1, to depart on count 1 from 165 to 330 months. The district court found both factors applied to both counts 1 and 2. But this court could find, if it did so, that the rape was still doubled by virtue of the crime of extreme sexual violence, and that the other factor applied to count 1, and his current sentence of 660 months would still stand because it would still be in line with what the district court did.
To do that, we would have to reach the future dangerousness aggravating factor.
If this court rejected that the crime of extreme sexual violence factor applies to count 1, then yes, it should address the future dangerousness factor.
In part, that's because you couldn't have a doubling of count 2 because count 1's the base sentence.
I disagree with opposing counsel on that one. I think you still could depart on count 2, even if you did not depart on count 1. And opposing counsel cited to one statute indicating that only the base sentence could be doubled. But if you look at KSA 216819 C3, that provision states that the total imprisonment term in a case involving consecutive sentences, such as this one, including the term for the departure crime, shall not exceed twice the maximum presumptive term for the departure sentence following aggravation. So this is the double-double rule. And I believe the double-double rule would still be triggered in this case, even if only count 2 was departed on. Count 2 could still be departed on to 330. But you won't arrive all the way at 660, which was the district court sentence here, if only that count is departed upon, because counts 3 and 4, I believe, were run concurrently. Had they been run consecutively, we'd be at 660 either way. But if only count 2 is doubled, then the resulting sentence will be the 330 from count 2 plus the 165 from count 1. And that's where the sentence would top out. Moving on to the future dangerousness factor, the non-statutory factor. That factor is sound, even if standing alone. While Mr. Newman-Caddell has argued that that factor standing alone should not suffice to increase his maximum sentence, his argument rests upon the federal death penalty statute that he recounted here today, that he briefed. But that statute explicitly states that a sentencer in the federal system is not permitted to go beyond or find aggravating circumstances unless first it finds a statutory aggravating circumstance. After finding a statutory aggravator, the sentencer can then use non-statutory ones. Our statutory system is not confined the same way. Our sentencing courts are not confined the same way. Furthermore, his argument that the non-statutory factor is he still raises the Apprendi argument within that claim as well. But I once again go back to what I started with, which was that Mr. Newman-Caddell waived anything relating to Apprendi by stipulating to his guilt, to the facts underlying the aggravating circumstances, to their substantial and compelling nature as a matter of law, and to the fact that they were not outweighed by any mitigators that he could present. Future dangerousness is not vague. These are terms that are easily understood by the general public. There's not a vagueness problem or a notice problem here, given that the statute itself states it is a non-exclusive list. And furthermore, our Kansas appellate courts have recognized future dangerousness as a departure criteria nearly as long as Mr. Newman-Caddell has been alive. It has been on the books as a factor that can be used to aggravate a defendant's sentence, durationally or dispositionally. And that's why I'm asking that you affirm both criteria. If this court reverses or vacates the departure sentence on count 1 by virtue of finding that it was not a crime of extreme sexual violence, this court should nevertheless find that the departure criteria of future dangerousness applies to count 1 to justify the departure on it. And furthermore, that criteria equally applies to count 2. There's no distinction between which counts that one would apply to, and the district court found it applied to both, and this court should find the same. It need not reach that future dangerousness issue if it recognizes that the crime of aggravated kidnapping here was a crime of extreme sexual violence. It is essentially undisputed in this case that the reason the 2 defendants kidnapped this woman after following her from the convenience store to her workplace parking lot at night was so they could rape and sodomize her. That's what they did. And that's what makes this aggravated kidnapping a crime of extreme sexual violence.
Could aggravated burglary also be a crime of extreme sexual violence under the same underlying facts?
I absolutely believe it could.
I was just trying to think of other crimes that might, you said the home invasion on the one witness.
Yes.
That would suffice under this theory because it's a crime involving, just under the state's interpretation.
I believe so. And the reason why, Justice Rosen, is that the intent, the purpose, the reason the defendant carried out the crime was to achieve that end. And Mr. Newman-Caddell, when he broke in, that other case would have been charged here, but it happened in Missouri. But that involved him breaking into an apartment home of a woman with her young child. And he proceeded to rape her in her bed while her 2.5-year-old child sat next to her in bed. And the child woke up and she held the child's hand and tried to soothe the child and tell the child it would be okay while she was being raped by this defendant. That aggravated burglary would absolutely be a crime of extreme sexual violence if committed in the state of Kansas. This defendant satisfied those aggravating circumstances. It's those underlying facts that support the finding that he was a sexual predator. And I'd ask that this court affirm his convictions, most importantly, confirm his sentences as they were imposed by the district court. Thank you.
May it please the court, Corey Cole for Mr. Newman-Caddell. The state said that it's you can use the factual circumstances here because the very purpose of the kidnapping was for the rape and sodomy, but that's not how if this court says that a crime involving non-consensual acts, you look at the individual facts, then that's not the floor for that. It doesn't have to be that, as I read the statute, it wouldn't have to be that it was the purpose of the crime or that it was somehow intimately related or like a burglary or an egg kidnapping, that it was part of the charge of the crime. As I read this, if you say it's the facts of the crime, then it's all the crimes. Theft, the Missouri case, probably the child endangerment, you could throw an assault on there. Those are all crimes sort of involving an act of sexual intercourse. If you're looking at the facts of the crime, it seems to me that I don't know that the legislature wanted this to be a trump card to be played on every.
What's wrong with that? Why, that seems like a potentially very reasonable legislative purpose. Say, look, if you're going to commit a bunch of crimes and one of them is a crime involving non-consensual sexual intercourse, that's an aggravating factor. That just seems very reasonable. I don't know that that's necessarily what they did.
That's right. Well,
but
it's
you're just arguing that's totally beyond the pale.
I think it's perfectly reasonable for the crime involving non-consensual, like for the rape.
I'm asking, why isn't it reasonable for all the crimes committed during this one course of conduct?
Because it seems to me that you're already getting, the legislature would know that you're probably being convicted of so you're already getting that crime. And it doesn't seem to me that based upon these, that the non-sexual nature, the acts of non-sexual intercourse would affect the other crimes, a theft or a.
Well, we're just talking about aggravating factors. Just consider the following hypothetical. There is a rape that occurs, and in the course of the rape, a theft happens versus just a plain theft. Just seems reasonable to me that that is potentially an aggravating factor. I mean, all we're talking about is aggravating factors. It's an aggravating factor of the theft itself.
Right. Yeah. And I don't think if that the fact if a guy goes to the house, sees somebody there, takes a wallet off the credenza. I don't think the taking the wallet off the credenza is made worse because a rape happened before. The rape is bad. The rape is certainly, and it's a level 1 crime, right? But as far as whether he took the wallet or not, I don't see how that is aggravated or made worse, or to the extent it could be doubled because of an act that occurred near the same time.
Why do we even have to go that far here? My question would be, what's your response to the situation where it is an aggravated kidnapping for the purpose of committing a sexually violent crime? That's by definition a sexually violent crime.
Right. Well, I think as I look at this, there are 2 ways to look at that. You look at the statutory definition, which is an intent to commit a crime, which doesn't have a sexual element to it. Or you look at the facts of this of the individual case, which in this case they do. I don't think you look at sort of what I thought of it as sort of a modified categorical approach. Sometimes we do in Apprendi cases where you can look at the charging document to see sort of what area this is in. And it doesn't seem like that's possible by a reasonable interpretation of the statute, that you would look at some sort of middle ground to see where you're not looking at what the actual facts were. You're looking at the charging document or something like this. I think you have to look at either the statute, which doesn't contain any language of non-consensual sex, or you look at the facts of the case. What happened in this offense? And which case, in this case, there were. I don't think there's an element where you look at what the charging document said, and that as where it's in the charge, as opposed to we were talking about a theft versus an aggravated burglary, where it would probably be in the charge. Did that get you there?
Think about it.
Well, thank you, Your Honor.
Thank you. Thank you to both counsel. Court will now be in recess until 9 a.m. tomorrow morning.